conversation.
Good afternoon. I'm Dan Mahoney, president of the SIU system, and I'm happy to have you all here for this conversation of understanding. Before we get started, I do have Dr. Wesley Robinson McNeese has passed away yesterday with his family by his side. Dr. McNeese was the initial Associate Dean for Diversity and Inclusion at the School of Medicine. When I arrived here in 2020, he was in the role of Executive Director for Diversity Initiatives at the system level. And I can say I quickly came to rely on Dr. McNeese's advice on a lot of matters. In fact, the conversation of understanding we're doing today is part of a series I developed with Dr. McNeese when I got here. So he's part of the first conversation and really all the conversations in the first couple of years. He also was very much involved. In fact, my first meeting told me we needed a system chief diversity officer who was full-time. So the creation of Dr. Caldwell's position, the title, the job description really all came from Dr. McNeese. I considered him a mentor, a friend, someone I relied on quite a bit. But his impact on SIU and the world long preceded me. He has done so many things. I know he served as a mentor to a lot of people. And in fact, just recently we named the physician pipeline preparation program that he developed in his honor. But there are so many ways that he had an impact on SIU and will continue to have an impact going forward. At this time, we ask that you please keep his family in your thoughts and prayers during this really difficult time. Today's conversation is focused on the recent Supreme Court affirmative action decision. We're here to engage in a thoughtful and respectful discussion about this landmark ruling and its implications for educational institutions and our commitment to diversity, equity, and inclusion. The Supreme Court's decision has sparked intense debate across the nation, and it's fitting that we as members of the SIU community come together to talk about and better understand its nuances, its impact, and its ramifications on our campuses and higher education in general. And we've gathered today some of the best legal minds at SIU to help us gain that understanding. So we thank them all for being here. And we thank you again for joining us today for this conversation of understanding. This, again, is part of an ongoing productive discussions that we've had across the system over the last several years, and helps us really to uphold the principles of anti-racism, diversity, equity, inclusion in everything that we do. So I'd now like to introduce Dr. Sheila Caldwell, the SIU System VP for Anti-Racism, Diversity, Equity, and Inclusion, who will introduce our panelists for today.
Thank you, President Mahoney. Just before I introduce the panelists, I do just want to quickly also just echo your sentiments. Dr. McNeese was my mentor. I've had a lot of respect and appreciation for him. And I just want to say to the family that you are in our prayers and we're praying for your comfort and strength. So thank you for lending him to us. He was definitely a great man and he will be truly missed. So now I would like to, again, welcome everybody who joined us today. For those of you who are joining on YouTube and also to our panelists today. You are participating in a two-part series focused on the Supreme Court of the United States affirmative action ruling, revisiting race, representation, and equity at SIU. That is our topic today. And today we have with us our best legal scholars who will help us deepen our knowledge of this law and its future implications. And starting with that excellent legal mind, I want to introduce our Dean for the School of Law, Dean Camille Davidson. She is the Dean and Professor of Law at Southern Illinois University School of Law. She joined the law school in July 2020. Most recently, she was a judicial hearing officer for the state of North Carolina, where she presided over hearings in the areas of estates, foreclosures, guardianship, claim and deliveries, adoptions, and legitimations. So thank you so much for being here, Dean Davidson. We now have Assistant Dean Ruiz, Michael Ruiz. Thank you for being here. He is responsible for career services, diversity and inclusion initiatives for the School of Law. And now we also have Attorney Cindy Buys. She joined the School of Law at faculty in 2001, and she served as a professor for the Director of International Law Programs and Interim Dean. She is a Fulbright Senior Specialist and has been a visiting professor at both Wales and the university in Poland. So that's impressive. Thank you for being here. And definitely last but not least, we have Attorney Deborah Nelson, who currently serves as our Senior System Counsel at SIU Carbondale. In this capacity, she represents the university in a wide range of legal matters, including labor, employment, litigation, faculty issues, athletics, and public safety issues. So again, we appreciate you joining us. And for those of you who are participating via YouTube, we definitely want you to listen to the different questions that we engaged attorneys with today and give you an opportunity to respond to those questions. So we will have this discussion from noon to 1 o'clock. And then at 1 o'clock, we definitely look forward to entertaining your questions that you will send via chat. And again, I want to introduce Doris Williams. She will be receiving those questions. So now that you've met our panelists, I would like to start with our first question that may be on people's mind. I know some of us know a little bit about affirmative action, but now I would like to go to Dean Davidson. If you could tell us, what is affirmative action? Why was it created? And who were the benefactors?
Thank you so much, Vice Chancellor Caldwell. Since we're all attorneys, I do want to start with a disclaimer that today we are not acting in any way in an attorney-client relationship. Everything today is for informational purposes only. We are not giving legal advice to anyone who happens to join us today. So with that in mind, wanted to just start with the question that you asked: what is affirmative action? At its basic core, affirmative action is any set of policies put in place to ensure equal opportunity and prevent discrimination based on a broad range of identities, including race, sex, gender, religion, national origin, and disability. Why was there a need for affirmative action at any point? Well, we think about the history of our country, and we have to remember that the Constitution did not include most of us. The Constitution included white landowning men. And then when we look at our country, we know that from 1790 until 1965, there were racial quotas in immigration. We know that our military was segregated from 1863 until 1948. Brown versus Board of Education, which stated that segregation in public schools was unconstitutional, was not until 1954. The Civil Rights Act of 1964 banned segregation and discrimination in all forms. And the Voting Rights Act of 1965 is what allowed the federal government to enforce the 15th Amendment in the United States South. So we first saw affirmative action in the employment sector. In 1961, President Kennedy urged defense contractors to take affirmative action to end racial segregation in their workplaces. And then the policy was made a formal policy of the federal government in 1965 by President Johnson. The concept of affirmative action in universities became a part of the vernacular in the mid-1960s. We know that Dr. Martin Luther King visited Harvard in 1965 and urged the university to take more Black students. And Harvard put in a very aggressive affirmative action plan in 1968. And by 1971, the Black population at Harvard was on par with the US Census. We saw other universities begin to do the same thing in the late 60s. When we talk about race, there are 5 categories of race in the United States, according to the United States government: American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, and white. And there are 2 categories for data on ethnicity, and it's Hispanic or Latino and not Hispanic or Latino. We first heard the concept of reverse racism in 1978, and Professor Buys is going to walk through a history of Supreme Court cases. But I will share, before I turn things over to the next group of panelists, that in 2022, about 95% of Black college students went to universities that did not take race into account in their admissions policies.
Thank you for that. A very helpful and informative background, Dean Davidson. And now, Attorney Buys, if you could just unpack a little bit further the history of affirmative action for us.
Sure, thank you very much. As Dean Davidson alluded to, affirmative action actually comes up in more than one context. I have a short PowerPoint presentation I'm going to share that describes some of the major Supreme Court cases in the context of higher education in particular, but it also comes up in the employment context, in the context of government contracting, and other areas as well. So I will share my screen now. And move my bar here. There we go. All right, so hopefully everyone can see the screen. And following some of the civil rights activities in the 60s and into the 70s, the first major case that went to the Supreme Court involving an institute of higher education was actually the University of California's medical school. And so we have a case called Bakke that deals with a quota that the medical school had. So they admitted 100 students each year, but they reserved 16 seats for what they described as racial and ethnic minorities. And they had a special admissions process for those particular minorities. And that was challenged by a man, a white male, who was denied admission 2 years in a row to the medical school and was not considered in the special admission process. And he alleged that he had better entering credentials in terms of his MCAT score and grades from school and that sort of thing, and was denied. The Supreme Court struck down the quota, and in doing so, it said a couple of things. And one of the things that it said is that because the 14th Amendment to the US Constitution guarantees equal protection of the law to all persons, whenever lines are drawn by a state or government institution on the basis of race, the court considers that to be inherently suspect, and it will subject such line drawing to strict scrutiny. That traditionally means in legal terms that the government has to have a compelling reason for using race in its decision-making or actions, and that any action that it takes has to be necessary or narrowly tailored to achieve that compelling government interest. In the case of Bakke, the court said that achieving diversity in higher education can be a compelling state interest. However, the means that the University of California Medical School chose, adopting this quota and reserving 16 seats for persons who were racial or ethnic minorities, was not a narrowly tailored means of obtaining that interest. And so this case, I think, really established this idea that first, it's important in higher education to have a diverse student body for a variety of reasons, but also that the court's going to look at that very carefully. It certainly did not give schools a blank check. We're going to fast forward quite a bit from the 1970s to 2003 and to the University of Michigan. And there were two companion cases brought, one against the law school and one against the undergraduate university for their admissions practices. And the allegations were, in both cases, that the university was impermissibly using race in deciding whether to admit particular students. In the case of Grutter, which involved the law school at the University of Michigan, the Supreme Court confirmed once again that obtaining a diverse student body at an institution of higher education is a compelling state interest. And at the law school, the admissions department or committee used race as what they called a plus factor in student admissions. And their aim was to achieve what they called a critical mass of different racial and ethnic groups. And they wanted this critical mass so that no one would feel isolated or alone, and also so that everyone would see that there's a diversity of opinion within racial and ethnic groups, and to break down stereotyping. And because the law school used it only as a plus factor and not as a determinative factor in their admissions process, the Supreme Court upheld the admissions process at the law school as being constitutional. However, they did offer a caution that they did not want to see race being used in admissions forever. In that case, they said, hopefully in 25 years, we won't need to use race anymore, that we'll have lots of students of all different races and ethnicities going to school, and we won't need to expressly consider race in the admissions process. In the companion undergraduate case of Gratz, the Supreme Court actually struck down the admissions program. For the undergraduate institution, they used points and they assigned points to different factors. So many points for having a certain undergraduate GPA, or so many points for being a, virtuoso violinist or something like that. But the number of points that were assigned to someone on the basis of race was so large, the court said that that became a determinative factor in the process. And so it wasn't part of the holistic review the way the law school was, and therefore the court struck down the undergraduate admission practice at the University of Michigan. And then the more recent case of Fisher versus University of Texas, the Supreme Court ultimately once again upheld a race-conscious admissions program under the Equal Protection Clause. And there the court said that it would continue to defer to the university's judgment that diversity is compelling as a state interest in the admissions process, but that the court was going to very carefully examine the way that the university achieved that interest, looking at their admissions process, looking at how that they used race. And they said that in Texas, the university had considered several race-neutral alternatives. You may have heard of the top 10% plan, where they take the top 10 students from every high school across the state are automatically admitted to the university as a way of guaranteeing admission and that does not consider race. But none of those alternatives were actually achieving sort of the critical mass that the university wanted of racial and ethnic minorities. And so the court ultimately said that the university could use race as a factor. In fact, they described it as a factor within a factor within a factor, that it was not determinative, again, in the admissions process. So this is the context that leads us to the current case we're discussing today, Students for Fair Admissions against Harvard, which again raises the issue, is diversity a compelling state interest in university admissions? And how can universities take race into account, if at all? And with that, I'm going to turn it over to our other panelists to talk about SFFA versus Harvard and UNC.
Thank you. Do we have any panelists who would like to comment on any components of the law that was just outlined by Attorney Biles? Okay, well, I would like to follow up and ask, what does this law mean for SIU? What does it mean for Students for Fair Admissions? And Mike, I would like to turn that over to you.
Sure. So in admissions, where I currently work, what most admissions professionals are looking at now is that the court has ruled over the summer with SFA. So to recap, remember you have Grutter says you can be one factor, but now in SFA, they're saying, hey, race cannot be a factor. So in admissions, at least here at the law school, other law schools across the country, the initial reaction was, well, we have to remove race information from people who review application files, right? And so what the concern obviously is, depending upon your view of whether the case is rightfully or wrongfully held, is what's going to happen if people can no longer view that as a factor, right? There also, of course, is this issue of with the court's holding in SFA, where there at least is a reference to the fact that, well, if the applicant brings it up on their own, then it might be okay. You just really shouldn't ask for that information, right? Or at least not give it to the people who review. So I think for schools like SIU and other law schools across the country, they have been using under Grutter race as one factor. The initial thing will be that, hey, all right, we're just no longer going to provide that information to people reviewing files. What will probably have to be litigated and decided by the court, future courts, are the more specific, refined questions. Can I ask, can I put a question in the application that says, hey, describe how your race has impacted your life and what challenges it may have brought to you. There's, depending on how you read the case, that's perfectly okay. But I imagine some people believe that it is not. And then, of course, as was already talked about, how does this then spell out into other uses of affirmative action in recruiting, in financial aid, and then later in hiring? So my guess is, like the cases that Professor Biles referred to, this is just going to be one in a long line of future cases that will begin to answer those questions.
Thank you, Dean Ruiz. So based on those comments, I know we talked about the admissions process, but can we elaborate, Deb, if you could tell us, how does this law at all impact recruitment in the categories of student, faculty, and staff? Which particular areas are impacted by this law?
So the Supreme Court case is specific to admissions for higher ed students. It really does not directly impact anything else in the opinion itself. Of course, it's going to have precedential quality for some of those other things, and the courts will, this gives us an indication of where the court might head. But the case itself was strictly about the use of race in admissions. And the court said a few different things in that I just want to go back and hit a little bit. One being that they sort of talk about the equal protection clause. So you have two different institutions being sued, one being a public and one being a private. So it pulls in both the Constitution and Title VI of the Equal Protection Act. And so what the court said is that there's sort of two commands of the Equal Protection Clause, and one's that race cannot be used as a negative factor and that it should not operate as a stereotype. And that sort of is a little bit of a key here of why the court is saying you can't use race as a standalone factor, essentially in the consideration of an applicant's application to your institution. But you can use how race has created other characteristics. Has it created the ability to overcome challenges? Has it created the ability to the determination, those types of things that are relevant in the admissions criteria? And that's a lot of where this law is sort of headed in some of the Supreme Court's statements related to the use of race in admissions when they were talking about that. So they wanted to limit it to characteristics, not the mere fact that someone has a particular race or skin color or ethnicity, things like that.
Thank you. And just go ahead, Dean Davidson.
I was just going to jump in just for procedural history. The case SFFA was an organization that brought the lawsuit against Harvard and the University of North Carolina. What we know is that the Supreme Court actually overturned two lower court decisions that said that the admissions policy did not violate the Civil Rights Act of 1964. So the Supreme Court actually ruled against what the lower courts had done previously. But what I think also is important in this case is not only was there the majority opinion written by the Chief Justice, there was a concurrence written by Justice Clarence Thomas. And so many people have taken the words in Justice Thomas's concurrence and attempted to make it a part of the majority opinion. In the majority opinion, the Chief Justice does not use the word colorblind. It is Justice Thomas who uses that word, that phrase in his concurring opinion. The Supreme Court in the majority opinion did not say that you can't use race when assessing an individual applicant, which is what Assistant Dean Ruiz just suggested. So if there is a situation where because of your race or gender or whatever that has caused you to overcome something or be inspired by something, the Supreme Court said, that's fine if you share that information with us. So the dialogue that's out there right now has sort of taken what's in a concurrence and sort of made it a part of what is actually the majority opinion. We've even seen situations where people want to talk about what's next with employment. And yes, there are going to be cases. There's actually cases already filed against law firms with respect to their summer associate programs that use race as a factor. So we know those cases are out there against two large law firms. But when we're looking at this particular majority ruling, we have to stay true to what is the law right now. And I think that's important. And I think it's important for us not to jump ahead. And I think it's important for us as an SIU system to stay true to our system president, Dr. Mahoney, and our university chancellors, where we have expressly stated this is an important component of who we are. And that's what we also want people to continue to know and understand, that the case in no way says to a university, diversity can't be an important component of your mission, of your purpose.
Thank you so much, Dean Davidson. That was very helpful as far as clarifying. And so what I heard you say is that race matters. So they did not say that race does not matter. It's just that it cannot be a determining factor in the admissions process. And so again, we're inviting applicants as they pursue it, they can talk about how they've been advantaged or disadvantaged based on their race in the admissions process. Thank you for that. Next, I would like to ask, what specifically is our policy? We've talked about affirmative action, we've discussed UNC, we've discussed Harvard, but what is SIU's policy regarding affirmative action specifically here? Deb, if you can actually speak to that.
Sure. So specific to admissions, SIU has always been a very open institution. We've had a mission related to first-gen students in particular. And so we haven't really used race in most instances as a criteria or a factor in our admissions decisions. We have taken other steps to be able to encourage diversity and obviously have lots of support systems and various things in place. But as an example that I've heard several times now, the elimination of the ACT is one of those things where when you're reviewing your processes and trying to increase diversity, that was one of the ways in which probably assisted us in having an even more diverse student body. So those have always been the processes and the steps that SIU has taken over the years, is how do we provide our opportunities to all students. And we've not had to use race or used race in particular as any factor in our admissions criteria.
Thank you.
For the undergrads in particular, and really broader than that, but just to be clear.
That was helpful. I know Dean Davidson said early on in her remarks that 95% of students were not impacted by the race conscious admissions process. But having said that, Mike, how do you think the Supreme Court ruling will affect diversity and inclusion at SIU, undergrad, as well as on law school campuses?
Oh, I think at the law school level, I mean, I remember now under Grutter, so we're still allowed to use race as one factor. And the law school here, my guess is other law schools were doing that. And so if race is no longer permitted, then like I said, at least here, the policy will be is that information, which used to be shared with the people who reviewed files for the law school, will no longer be shared. They will no longer have access to that information. It will now only be if the applicant brings up in a personal statement, will that information be given to the people who review files. So that is a major change for the law school and for law schools nationwide. And then the impact of that just remains to be seen. We can talk more about that, I know, in a future question.
Well, thank you. Any other comments on that? Okay. So Cindy, if you could just share, based on that, the impact remains to be seen, but what can we do now at SIU and other campuses across the nation to promote diversity in the admissions process, and how will we continue to value anti-racism, diversity, equity, and inclusion? Because again, that's a part of our mission here at SIU.
Yeah, I think both Dean Davidson and Deb Nelson talked a little bit about the part of Chief Justice Roberts' opinion in the Harvard case, in which he said that it's perfectly okay for a student in their college admissions essay to talk about, their life experiences. And if that includes discrimination or disadvantage based on race and how they have responded to that or overcome it, that's part of who they are. And, they can choose to share that with a college admissions committee. But in addition to that, there are a number of other steps, I think, that universities can take. They can continue to recruit at high schools or in geographic areas that have large minority populations. and that may increase the pipeline of students coming through into the university and into law schools from those areas. Deb Nelson mentioned the idea of first-generation students. One of the reasons we have affirmative action is because so many students historically from racial and ethnic minority families were not able to attend universities, right? So if we are looking at first-generation students because their parents or grandparents, were not able to attend because of legal exclusion under segregation policies or because of other economic or other disadvantages, looking at first-gen students is one thing that can help to overcome that. Considering social and economic disadvantage more generally too, outside of race, helps us to bring in a diverse student population who bring many different experiences with them that diversifies our student population in many different ways. And I just think in general that, we can continue to educate our community. We can continue to have conversations like this. We can continue to do education about discrimination, about bias, about the ongoing impact of racism that was, part of our history and that continues to unfortunately affect many different institutions in our lives today. And so we can continue to, do our educational role that we have always done. So those are some things I think that we could continue with.
Excellent. Thank you for those different steps. Again, that will help us to continue to promote diversity in our admissions process. So again, the recruitment piece is not, again, outlawed, and we can continue to pursue students from different backgrounds. Now I would like to know, we've talked about affirmative action. One of the things that was not a part of the law was legacy admissions. So can we talk a little bit about legacy admissions and how these policies have been impacted by the affirmative action ruling? Deb and Dean Davidson, Camille, if you could speak to that.
So I mentioned that there is now a challenge against Harvard's legacy admissions. Obviously that will ultimately work its way through the court systems and we'll determine how that works. But one of the arguments, at least related to that, is legacy admissions essentially grant students who in these time periods that Camille or Dean Davidson talked about early on, who didn't have those opportunities to even have a family member in college, they're now excluded from that point or consideration. And so there is an impact there historically that we know about, and that of course is the basis of the challenge. I'll let Dean Davidson speak further.
And when you do, Dean Davidson, can you just go back and tell us what legacy admissions is and a little bit about the background of that? Thank you.
Sure, absolutely. So legacy admissions would be taking into account the alumni status of an applicant's parent, right? If the parent attended the institution. So what I think is important for this discussion, and I'm going to defer to Professor Buys as our con law scholar, to talk about levels of scrutiny and when a court uses a particular level of scrutiny. And strict scrutiny is the highest level of scrutiny. And because this was a protected class of race, it is at the level of the highest scrutiny, right? And so in this particular situation, the court said it did not, right? As we look at strict scrutiny, the universities could not show that their programs, that there was a connection between their programs and the goals that they claimed that the programs pursued, if that makes sense. People get a check for many different reasons, right? There are people from rural communities, when they apply to Ivy League schools, get a check, right? Because they're filling that diversity box, and so on and so on. What's interesting about this whole dialogue is it really doesn't apply to most colleges in the United States. So when we think about 3,500 institutions of higher education in the United States. We're talking about probably 100 or so schools when we are talking about how the race conscious consideration affects things and how the legacy affects things. So we're talking typically about Ivy League schools and public Ivy League schools. So when we talk about the most elite institutions, if race is taken out of consideration, about 40% of Black students would be removed. But if we took away legacy status, about a third of white students from the same institutions would be removed. So it's sort of, the data speaks for itself. But I think most importantly is so many people in our population assumes that SIU, for example, has this, we need X number of insert appropriate category persons. And we've never had targets. We've never had quotas. That's not ever been a part of us, or to my knowledge, a majority of state institutions. But when we're talking about those most elite institutions, that's where that concept of or issue about legacy status comes into play. And that is where we see most of the aggressive affirmative action policies as well.
Okay. Thank you for that, Dean Davis. And I actually do have a follow-up question. I know when we talk about on an undergraduate level, a place like Harvard and UNC considering race-conscious admissions, but what does it look like for a school like ours? We are research-based, we're a public regional institution, we have a medical school, we have a law school, we have a dental school. Do you think on those professional levels that affirmative action will have an impact when you remove race as a consideration?
Well, I think I can speak for law schools in general. We've been preparing for this. The SFFA case was not a surprise. We had been planning for it. We already knew that 9 states had already stated that race had not could not be taken into account. So I think all of us were already following and looking at what was going on in those states as well. The biggest thing that I would advise to people is don't take yourself out of the applicant pool. Don't take yourself out of the running. I think so many people, it's perception versus reality. And when they see something like, oh my goodness, the Supreme Court has said this, I'm not gonna, there go my chances, right? And so it's this self-selection of I'm not going to apply. And so I would say in all situations, don't take yourself out of the pool. Continue to do what you have always done. And hopefully, if we can continue to do what Dean Ruiz suggested, which is, and Professor Baez, which is to continue that pipeline building, right? Continue to go to the schools where we recruit, continue to speak to individuals, especially those who are first generation, who don't really have anyone to tell them about the graduate school or professional school application process. I think is going to be really important on our part, because it's going to be keeping that pipeline open and diverse so that the applicant pool is there.
Excellent advice. Thank you for that feedback. I know earlier you just mentioned the 9 other states who had banned affirmative action prior to the Supreme Court ruling. So Mike, can you tell us a little bit about what we can learn from those other states and how it impacted their admissions process when affirmative action was banned on their campuses?
Well, the 2 that I'm most familiar with are California and Michigan, and the results out there are not good, depending on what your viewpoint is on this issue. If you look at what happened at universities and law schools in particular, when those states passed those constitutional amendments, the number of students in those classes dropped, in some cases dropped significantly. So I think there is a concern nationwide that you will see, at least initially, a drop. And so the hope is that, like Dean Davidson said, that schools can figure out a way to widen the funnel, to use an admissions term, to increase the pool, to figure out other ways to identify the students that they're trying to identify without using race as a factor. It's going to be a challenge, but I don't see how it doesn't have, at least in the immediate impact, a drop in the number of students represented at the university and the law school level, especially at what people would consider the more selective schools.
Any other feedback on that? That's a sobering and I think accurate analysis. So thank you for sharing that.
Yeah, I think that we have to keep in mind a lot of the things Dean Davidson has said, at least we had some concern or warning that this might be coming. And so this was one tool in the toolbox, but it's certainly not the only tools to address this. And I think hearing the experts in this area and the individuals responsible for this in the steps that they've already been taking and the steps that they're going to continue to take to try to minimize that impact also has to be emphasized here. Yes, we've lost this one tool, but that certainly isn't the end of the repair work, so to speak, that all the institutions are likely taking on, but certainly SIU.
Excellent, yeah. Thank you for sharing that. Like you said, we have other tools in the toolbox that we're drawing on to ensure that we continue to promote diversity and equity on our campuses at SIU. And one of the final questions I have for the panel right now is that we've actually, had an opportunity to discuss today. Many of us have looked at other webinars where they're trying to be clear about what the facts are as far as affirmative action. But I would like to know, how do you think the Supreme Court's ruling will influence public perception and discourse on race and racism on our campuses and society? What do you think this perception is communicating? This law has communicated to the broad public. Dean Davidson, I'm going to ask you to lead with that.
Sure. So in my intro, I gave an outline of the history of this country, and it wasn't until 1965, with the Voting Rights Act of 1965, that we saw really freedom for many people. And just to put it in context and to tell my age, I was born in 1967. So I'd like to think that wasn't that long ago. And I think when the Supreme Court, and I will characterize this as this is my personal opinion and has nothing to do with me as Dean of the School of Law, but I think that many people believe that when the highest court signals with a case like this, that it has stated that we are fine, that there's no more discrimination, that everything in the past was in the past and it's no longer an issue now. And I think if we're all serious, we know that 1965 was not that long ago. And in this country, we still have a lot of healing to do. And if we can't recognize our past, we can't get to where we need to be in our future. And so the concern that I have is for a population of folks who will say, well, the case just says we're treating everybody the same. And isn't that what we want to do? There's a difference between equity and equality, right? If I've got a broken leg and I've been in a cast and you've been training for a marathon for a half of a year, and you put us both at the starting line the day after I get out of my cast, there is no possible way for there to be a fair competition. There's no possible way. Equity and equality are not the same thing. We have to understand that people are coming into a place or space from a different starting point. And I think we owe that to ourselves to recognize that as something that we all have to deal with on a daily basis. Nothing happens by accident. It only happens when we pay attention and we are intentional about remedying past wrongs.
Thank you. And that's a perfect segue for me to just remind everybody how we define equity at SIU. We define it as we have to make right, act right, and do right. And I'm going to go back to that first definition, make right. And when you're trying to make things right, you are considering the historical wrongs that have happened to different groups throughout American history. And you're thinking about what are some of the ways that we can compensate and remediate that. So again, we can have a level playing field. Equality says we're going to just ignore the past and we're going to treat everybody the same now as if there was not a past. And we have a lot of evidence to show how the past has really negatively impacted people with respect to student success, with respect to the housing industry, with respect to healthcare, incarceration rates. It's really not a part of our society that's not impacted by the historical wrongs that have happened to disadvantaged groups in America. And so for us to just say it's 2023, we're going to just ignore that and move forward as if nothing happened is, intellectual dishonesty, because it should not happen. And so again, I appreciate those comments. Are there any other panelists would like to speak about other perceptions and its impact on higher education and society based on the Supreme Court ruling?
I'll jump in and just add something to what Dean Davidson said and what the future might look like. She mentioned that we have a concern about the message that people take away from the Supreme Court's recent decision and Students for Fair Admission. And there have been individuals and organizations who have seized on that. So for example, there was a group of attorney generals from mostly right-leaning states who have written a letter saying that they believe that even though the Supreme Court's decision is limited to admissions in universities that are subject to either the Civil Rights Act or the Equal Protection Clause, that it applies more broadly to other contexts, to private schools that may not receive federal funding, to private employers. I think there was a mention earlier of a lawsuit against law firms in their hiring and recruitment practices for, summer associates, meaning, law students. And there are definitely those who are taking the signal from the Supreme Court that the consideration of race or the recruitment of diverse categories of persons in other contexts of life may also be affected. And so the implications could be broader, even though the Supreme Court's decision for now applies only to university admission processes. And one interesting thing that wasn't raised is that the military was an intervener. Really, we call them amicus, friends of the court, in both the older Grutter and Gratz cases and in the more recent Harvard and UNC cases. And they argued the importance of diversity in military ranks and that it was important for the military to recruit a broad and diverse population of individuals to serve in the military and to promote them into leadership roles. And it was important for harmonious relations and learning to deal with different people and things like that. And the Supreme Court specifically said in the Harvard case, we're not extending our ruling to the military. It's a unique case, but it didn't say why. And so, we are left with some questions about, why did they view the military as being potentially different? And are those arguments that might apply in other contexts as well? So there are a lot of unanswered questions still about where this goes, but I think Dean Davidson is right that there's a certain signaling here about the Supreme Court's view of race in society that may be interpreted much more broadly.
Thank you. I appreciate you mentioning the military, because that was something that we did not discuss. And it is interesting to see how they were exempted and some of the reasons that they actually outlined for that. Again, so thank you for sharing that. Any other closing comments for this question? I do want to take a moment, as we've talked about the scope of the law. I'm hoping I'll still have my job after I put the president on the spot. And so if you could tell us how SIU, we've shared about, again, the law and admissions, but again, as far as our temperament with this law, how would you like to see us move forward and execute based on the ruling?
Yeah, so I'll say just a few things. One is, I think Dean Davidson said it very well, we're like a lot of institutions, that there's only a small amount of our admissions that's actually directly impacted. So in many ways, it doesn't affect our focus on anti-racism, diversity, equity, inclusion, and really what we're doing from an admissions standpoint. When you look beyond and what may come next, it's interesting. The employment discussion is one I always find kind of fascinating. The discussion about the law firms and being a focus of it. And there's been lots of talk about, will this affect how we recruit people? But in higher education and hiring roles for 30 years, never have I hired anybody based on race or gender. That is, we don't do that, and we actually don't give points. That is not how searches actually work. And so it doesn't really affect what we do. A lot of what we do, much like I think the discussion today has been focused on with the admissions process of those universities will try to do something different in the recruitment. And the one thing we may have done is try to recruit a more diverse pool by using more different avenues to recruit people into the pool. But once we have created that pool, race was not something that someone got bonus points for or was not a factor in those hiring decisions. So in many ways, our commitment to increasing, diversity of our employees is really much more about making sure, again, everybody has a fair and equitable chance in the process, and we're recruiting a diverse set of candidates, and that won't change either. So in many ways, I think a lot of the things that we've been working on doing aren't going to be as dramatically affected as perhaps some other institutions. The other thing I would say, and I think it's interesting, Mike brought up the Michigan and California cases, which I'm also very familiar with. And one of the things that was interesting in Michigan, I saw their president present recently, is they have they went down, I think it was about 9% to 4% of their students were African American. They've committed $82 million in additional recruitment funds to help make up for that. And I think they got it to 6. The fact is, even with that commitment of resources and doing things differently, it hasn't gotten them back to where they were before. And I think both because of what this will impact now other institutions, as well as I think Dr. D. Davidson talked about it well too, is that people won't apply, unfortunately, even if they would have been admitted. I think we will continue to see an increasing diversity in our student populations across the SIU system, because when they don't apply to some of those institutions with more restrictive admissions, they end up often at institutions like ours. And so we are seeing an increasing diversity of our student population that will probably be enhanced by the decision, because again, those students will go someplace else, and we're one of those places that they will go. I don't know if you have any other questions, or I answered your question.
No, you did. But I think one of the points that you brought up is that I would like to, because we have a few more minutes, I would like to explore. We've talked about the perception that people might not apply, and just say again, this law is signaling that everything is equal now. So what are some possible implications, not just to people not applying, but that if diversity does increase in our law schools, if it increases in our medical schools, maybe not specifically undergraduate, but when we look at some of these more professional programs in regional institutions and beyond, what do you think the future implications of that would be if we went down? Like you said, they spent 82 million and they went up 2%, right? So what would that look like for us and even for society to have less diverse people in those significant and meaningful roles in society?
Well, diversity in all of its forms is so important for the legal profession, whether it's race or rural or gender. So much of who we are is because of what we bring from our individual experience. And the only way to really have access to justice is to train attorneys who represent the people, represent the population of individuals that they will provide services to. So it's important for classroom dialogue. We read cases every day where the cases are in the book because there was an issue. But if you peel back the onion layer, sometimes you can see that the court had no women or, no person who was LGBTQ+. And so you could see how the outcome of the case could be different depending on who the attorney, depending on who the judge. And so that's why I think it is important for us to have a diverse population of students together learning from one another. If you don't get the perspectives in school, there are very few places to get the perspective once you graduate.
Excellent. No, thank you for that. And I think one of the things that have been very consistent in studies about what is the benefit of diversity, one of the things that is very common is problem solving and innovation. So when you talk about those ability to problem solve, less diversity decreases those opportunities. And again, we make more mistakes and we're not as efficient as we could be because we didn't bring more people to the table. So thank you for sharing that. So now we're going to turn over to our panelists to see, again, if they can entertain questions for our participants who have joined us today. So one of the questions, and I think this was based on a comment earlier from Dean Ruiz, you talked about a drop, like when we looked at the band across the 9 colleges, President Mahoney mentioned it as well, the drop in the University of Michigan, California, other places, specifically after the ban on affirmative action. And one of the questions was, could a part of that drop be that colleges are still figuring things out? And I think even as a result of the law, but has that drop maintained over years, right? So it wasn't just that, oh, they had to adjust to the new affirmative action law and figure out different ways to recruit. So I believe that's the implication of that question. Is it that we will lose students because we're trying to figure out how to adjust to the new affirmative action law?
I think there's probably, that's accurate. And I think that for the 9 states that were at a competitive disadvantage, maybe if there's any silver lining from the case is that everyone now nationwide is in a similar boat that those states were in. But I think, as Dean Davidson brought up, schools will respond by trying to figure out, well, why were you doing this in the first place, right? What were your values? What was the goal you were trying to reach by including race as a factor in making some admissions decision, right? And if you were trying to make sure that people from different socioeconomic backgrounds were represented in the classroom, or were represented, to use a legal term, after law school in their communities. So I think that universities and law schools specifically will go back to the drawing board, and we see this in other legal areas. Not to equate tax law with higher education law, but tax attorneys will tell you that it doesn't take too long after years of regulations where people figure out, okay, well, there's a different way to do this, right? And then people go back to the drawing board and start all over with a whole new set of regulations. I think you'll see the same thing in higher ed admissions. You heard a lot about recruitment. I think there will be a lot of focus on recruitment, but I also think that schools will adapt. They'll figure out, okay, well, all right, you don't want us using this one thing. Well, there are other ways that we can achieve the diversity that we're trying to reach without specifically, having someone look at someone's race as a box on the application. That will take some time. But I think there's now a motivation to do that. And so, as the person asked, yeah, I think people are still figuring that out. And I do think they will figure that out.
I think Attorney Nelson said earlier, toolbox, and she used the term toolbox, which I think is absolutely appropriate, right? There's lots of tools in a toolbox. We figure it out, right?
Excellent. And I know earlier Attorney Vise spoke about specific things that we could do and how we can still, again, stay committed to our mission, because even though the law, again, speaks about affirmative action, SIU is still committed to being a place that is anti-racist and that we promote diversity, equity, and inclusion in all of its forms on our campuses. So again, I just want to say for the benefit of everyone who's watching and listening, that is the case, that we're going to continue with our mission in that regard. Do we have any more questions from our panelists, from our participants today? Well, we have received feedback that this has been very helpful and as well as informative. And so I'm actually going to give you back your day. And I want to thank you all so much for being here today. I'm going to give you a round of applause. I learned a great deal from you all. And for those of you who are watching on SIU YouTube, please join us for part 2 of this discussion on October 24th at 12 o'clock. So we'll be sending out more information in that regard. And again, thank you so much to our legal scholars and experts who have joined us here today.